Ready?
Yeah.
So, thank you guys for showing up. This is not a committee hearing, so it's not going to be run like a committee hearing. But this is our working group, and Linda and I wanted to make sure we did have an opportunity to hear from some folks, and that we made it available for everybody that wanted to participate and hear about. And yes, go ahead, use your thing. Oh, yeah.
I said too. Come here, you and I are good.
They're going to switch places, so we at least start with the appearance of being, you know, not separating the boys from the girls.
It looks funny. Okay.
It does. Thank you. Thanks, Nicole.
Yes.
Thanks, Tom. So, just a few brief comments from both of us, I guess, here about today. We want to take this opportunity to hear some testimony from some advocacy groups and from a survey that was done, an anonymous survey of our staff that was done by some folks at UT who are going to be reporting to us, to get updates from our council about the incorporation of the recommendations that we made as we had our discussions, and see if there's anything further we need to do there. And what we hope to do is to be able to put all this together within the next couple of weeks so that we can meet our timeline of during the first week of December, getting our recommendations to the speaker and to the other members. So that's what the purpose of today is. And Linda, you want to say something?
Yeah, just briefly. Just want to thank the speaker's staff, the speaker's attorneys for helping us out. Of course, UT helping us out as well, and the invited testimony today from various associations. But most of all to the task force. They have spent several phone calls with us on several hours of deliberation and reviewing different materials, and so we certainly appreciate that as well. So thank you for your good work on the committee, and my co-chair Donna, thank you for your good work on the committee.
Thanks, Linda, and to the rest of the group. And like I say, this is not a committee hearing, so we're not going to have to follow the same kind of formal procedures, but so you don't need permission to speak. You just chime in when you want to. But what we are going to do is try to get this through by noon, if possible. And so let me just go ahead and get started unless somebody wants to say anything right now. Okay, well, we'll call our first invited testimony up, and that is Dr. Noel Langet, or however you say your name. You'll have to tell me how to say it correctly.
Like if you take a plane, you land it.
Landed. Oh, very good. I knew you had something to help us do that. And even though it's not a hearing, just for purposes of everybody that's listening, if you can identify yourself and who you're with, and
Certainly.
Then go into your testimony.
Certainly. Thank you for having me and inviting us to participate, Representative Coop and Howard. And my name is Noel Landet, and I'm an associate director and lecturer at the Steve Hicks School of Social Work, just a couple blocks from here. And I live in Northwest Austin, so there's lots of connections here. I direct this institute that's been doing research in the state since the late 70s, and we currently participate with state agencies in collecting employee attitudinal data. So we collect employee engagement data for almost all state agencies and been doing that for a long, long time. And they use that as part of the strategic plan. So we're really used to asking a lot of people a lot of questions about where they work and the things that they do, including issues around harassment and ethics and so forth and so on. Just as an example, last year we just completed surveying about 75 state agencies and about 250,000 state employees. We also do customers of state service. We just surveyed 1.6 million customers of state services. And we work a lot with agencies on leadership development, so we do a lot of that as well. It's kind of as a background, this bipartisan work group asked us to do an assessment on sexual harassment, and I used a graduate student who assisted us, who's sitting in the back, Danny Shea. He assisted in putting together this report as well. And we administered this feedback, if you will, instrument to really try to ask House staff employees and members what they thought of the past policy. So we were looking back in time, not forward in time. It's really important to engage employees on all levels and get their opinion and to offer it to all employees. And so that's what we did. It wasn't to designate whether or not sexual harassment occurred. It's just like looking at the survey. It's a fairly brief assessment, and so I'm just going to kind of go over it, and I'd be happy to answer any questions either after or doing. We did provide this technical assistance. We invited all House and member staff employees to participate. It was an email that went out from the House clerk, went out on October 15th. It came back around the 16th, And the outgoing email contained information regarding the current policy, as well as a link to that current policy so they could look back.
And let me just interrupt,
Yes.
tell everybody, you've got a copy right
Yeah,
here?
you have the
Okay.
survey results and the
the-
letter.
Of the letter that went out too.
And on the bottom of after the letter is the actual assessment, and you can see it's pretty brief. It consisted of some responses. People were asked how much they agreed or disagreed with statements, and then we compiled that as well, and it had some open-ended stuff as well. We got back about 160 completed assessments. When you look at anything that's voluntary response rate, and it went out to roughly about 1,200 people. When you look at voluntary response rate, you want 10% or so, and you all got that. You got closer to 15%. We did ask some demographic and job characteristic questions, but we did ask fairly broad ones because this was an anonymous survey. We wanted people to be very open and honest about it, so we didn't ask very specific stuff. But we did ask gender, of which 82 respondents were female, 48 were male. We also tried to get a sense as to who and how long they've worked for the house. Most people work from 2 to 10 years, over half. Then we had about a quarter on either side, less than 2 and then more than 10. Again, the items were asked on a 5-point scale from strongly disagree to strongly agree. The items were positively phrased, so everything, the higher the score, the better the score. And we then kind of reported, and you can see on the sheet of reporting, the one with the blue bars and the orange bars, we lumped the agreements together and we lumped the disagreements together and then left neutral as gray. So as we did that, you want agreement responses. You don't want disagreement responses, and neutral responses in a very good place to be either. You want agreement responses. The first item in the survey kind of assessed and looked at the clarity. It says, I think the current sexual harassment policy is clear and understandable. 79% of people agreed. 4 out of 5, that's pretty good. 5 were neutral, 15 disagreed.
Sorry, let me interrupt. I'm sorry to keep doing that. Make sure y'all understand this is the current policy that we adopted in December. So it's the policy that we've been revising over the past several months, but from the December policy. Okay, thank you.
Yeah, no problem. The other item looked at the training that's provided, the computer-based aided training that was provided, and the item was the computer training I received on the House sexual harassment policy provides a good understanding of the issue. You had 72% agree, 8 were neutral, 20% disagree, and now you're starting to approach where, do I really want 1 out of 5 people to disagree with that item, that the training was unclear, which kind of leads to maybe, the training could be beefed up a little bit as well. When we look at other types of surveys regarding training, we often find that it's essential because the definitions around what's harassment and what's an ethical violation are very, very broad. People have a lot of different meanings assigned to that. And it's really good to have training that really focuses on people as to what not only the legal definition, but what's the culturally acceptable definition within the organization. The results do mean that there was a strong majority of people had a positive association with the training, but there's still 1 out of 5 that didn't. The next item examined the extent of retaliation if a complaint is filed. Now here we kind of have a difference. Before we had 3/4 of people agree with the items, and now we're only getting to half of the people agree with the items. And so we're really looking at the last 3 items. If I filed a sexual harassment complaint, it would not negatively impact my job. If I was accused of sexual harassment under the House policy, I believe it would properly be investigated, and if found false, would not impact my job. There you have only about half of people agreeing. And I would feel comfortable reporting any sexual harassment that, if I had knowledge of, to the House. And again, you have half. What you kind of have is a difference between, I think, most people feel the policy is pretty good, but in practice, it's a little more questionable. That is not on, I don't mean this as any type of excuse or justification. That's not uncommon. But again, that's something an organization wants to work against. So then what happened is after we did the quantitative items, we did have the ability to ask 2 different questions. They were looking at the barriers to reporting sexual harassment and then suggestions to improve the policy, which is, I know, is something of particular interest to the committee. The first item was, what would stop you from reporting sexual harassment you witnessed or experienced under the House policy? You had a lot of people write in comments like they feared that reporting would ultimately mean losing their job or affecting their reputation. And it was kind of centered around this idea of what I would consider to be like an unsupportive organizational culture. They were unsure. I did have some comments that said, I don't fear it at all. My rep would stand up for me regardless of what I did. To other people saying, I think it would impact the way my job was. So there was a big difference there. There was a lot of concern about clarity of definitions and the reporting process. But there were a third of people that said there's no barriers at all. that they would definitely do it. When we ask for suggestions, what part of the policy, if any, should be clarified, there's always issues around how to make it more clear, how to make the policy do better at explaining definitions, to be able to outline in a more precise manner how to file a complaint. A lot of interest in what is going to happen next. If I file this, what is the timeline or consideration? And the policy, this was an interesting thing that kind of surprised me a little bit, is that not only were people gave comments about harassment within the house, and they weren't saying there's harassment, but they're having the, what do we do about harassment internally, but external factors as well. People coming in, constituents, lobbyists coming into the offices. How do we address that? Which is more tricky. How do you balance that? But that is something that they did raise, and particularly around how confidentiality would be preserved. So this type of feedback mechanism really gives you some direction. It kind of tells you kind of the current pulse. Moving forward, if you wanted a different evaluation of this assessment afterwards, we probably would get a little more precise, maybe use a stratified random sample or some sort of way to really delve in so that we're able to tell with a lot of clarity what the extent is. But this feedback, I think is fairly valuable.
Dr. Landit, appreciate your comments. I was just curious, so big step off here between question 2 and 3. And I'm just wondering, in your data set, did you dig into that a little deeper? Were there gender differences in terms of how people perceive those last 3 questions?
There were
Could you
gender
comment
differences.
On
Yeah,
that?
I sure
and
can.
maybe experience of the staff, did that play a role as well?
Experience of the staff did not, right?
Okay.
And when we looked at gender, there were some slight differences on when you look at the top 2 items, men felt more positively about that than women. And when you looked at the bottom 3 things, it was kind of a toss-up. Again, it's difficult. I mean, it was like half women and half men, about the same. Now, that's a difficult thing for me to answer, though, because we used an anonymous nature for the survey, we weren't sure of who was going to take it. We couldn't control the population. We don't know if we had a representative sample of men or women. It was just a feedback mechanism in order to participate. So I can't say with certainty, but of the people that responded, for the last 3 items, it was as much men as women.
So with regards to the survey responses you collected, did it identify the respondent based on their gender or based on their length of service?
They self-selected that, or they could have left it blank. So they self-selected whether or not, and had to answer it, whether or not I was a man, woman, or we had whenever you do an anonymous survey, you always want an opt-out kind of thing. So we had that as well.
I think that's important for us is if we're talking about culture, and obviously there does seem to be a fair amount of agreement that the policies seems to be fairly clear. I guess 79% is passing. I suppose, I'm an A student, so I'd like to see it 90 or better.
Yeah.
But it looks like the majority of folks, at least for questions 3 and 4, didn't agree that is that just uncertainty? I've never seen this unfold. I don't know what will happen. Or is this sort of reflect a general distrust based on something else? Or, I'm just looking for a little more guidance there because I think you uncovered something interesting.
And I agree with you. I do think it's an interesting finding. Again, this is a look back at the past policy, not the future one. And so, the kind of the methodology that we use doesn't allow me to give a clear definition of that, but it does suggest that moving forward, I would delve into that a little more detail. I would ask more specific questions. I would make sure that just because a number or survey reveals something doesn't necessarily mean that it does unless you can.
I almost read this kind of like, it sounds good on paper, not so sure how it's going to be put into practice kind of response,
yes.
Right?
Yes.
I don't know. It doesn't seem like it's going to work out the way that it says it's going to work out.
And that's
I'm reading.
Yes, they think the policy's okay. They just don't know in practice if the organizational culture will support them in that type of
And how do we change that? Any thoughts on that?
Yeah, you change it by very strongly reaffirming a policy, having a very clear and concise policy, having leadership that says, this is important to us, we will stand behind this, we do support you, and you make sure that employees feel very safe in reporting it and supported in that.
So do you almost have to wait for occurrences to occur in order for that message to get out? Or, how do you proactively get that message out without actually having to let everybody see how it plays out in real time? Do you understand what I'm asking?
I think, yes. I think promoting the work of your work group is very important, that employees know that the House is taking this very seriously and working with it in order to address it. I think that's something very important for employees to know, that we're on it. We're not shelving this in the back. We're not saying this is unimportant. But then moving forward, and I understand that you're working on the next set of policies along that line, making sure that all employees understand that, feel reassured by that, realize that that's there for the benefit of the whole organization.
So one of the things I want to ask you about, and it said that this was to all staff. I remember I responded
And to members.
into members too, so it was all people in the Texas House. So
Correct,
part of
including
that.
staff here and remote staff.
Okay, so am I to read this that more females responded?
Correct.
Okay, and the title is sexual harassment. Is that something? Have you studied whether changing the title to something that would be more broad, to say something like workplace safety? Would that be something that would try to encourage more participation? Or do you think that the title is something that would deter people, or maybe have some
Yeah, I know
type
where you're
of,
going with that, yeah. I don't know if giving it another, I think you could call it a lot of things and people would still relate it to a sexual harassment type policy. However, having said that, I think it's important for organizations to ascertain and to promote whatever their organizational culture is. This will be a safe place to work. This is a place free from harassment, free from unethical behavior, free from discrimination, whatever that is. I mean, I think organizations want to promote that. So if that's a general house conduct and safety policy or whatever that's titled, does that harassment word impact it? I'm not quite sure.
Okay, because that's something that I would like, I wouldn't mind considering, is saying workplace safety, because that's encompassing everything in terms of, free from harassment, discrimination, quality. I want to make sure that, we're considering these things when we're talking about that type of policy.
Yes.
And so, this would be something that, we would include, and I wonder if we would get more participation.
You very well could, yeah.
Okay, thank
Yeah, I agree.
I think it's good that you put in their suggestions on how to improve the policy. I think that those suggestions are actually very good suggestions. The concern I have more is on the questions that were asked with regard to how it's going to impact my job, where I see that there was some real concerns there on 3 and 4, and there's no suggestions on or what could be done with something like that when you're bringing about a new policy.
I think the biggest thing that kind of pops in there actually fell into the barriers, and that's that unsupported organizational culture. They feel as though if they reported it, it would impact their job. And I think there needs to be a lot of reassurance to employees that, in fact, that wouldn't happen, that there would be safeguards and confidentiality and process and understanding and how it would be worked through, so that they did feel confident in it, that the organization did support them. Whereas you have about half the people here that maybe they would, maybe they wouldn't. I'm not sure if I want to report that. We go through the same kind of training at UT Austin. We go through that, and they make it really clear that if you see sexual harassment or you see any type of harassment or inappropriate behavior, you have to report it. That is your job. The supervisor has to report it. Even if it's even remotely questionable, I have to report it. And that assurance is made of all employees. And so that is a reassuring thing that not only your supervisor, but your supervisor has to report it. We're going to have an open. It's going to be out there. It's not going to be shoved beside.
Okay. All right.
I think one of the issues probably that we have in the House is that, we're in charge of our own staffs.
Yeah.
So
Yeah.
it sets up an unusual type of situation. And the reason probably they don't feel as protected
Yeah.
as they should is because there is a human resources department, but that is really not where the complaints go. And so that line, that chain of how you report and where do you report and that kind of thing is a one-off of most businesses, and that probably causes some anxiety in the workplace.
Yeah, I would totally agree. I know when everybody says, "Oh, we're different," I'm always like, "Are you?" But you all are different. When it comes to this, you got me on that one. You all are different. We have a centralized reporting person that we report to at the university, and we have a centralized an HR person, blah blah blah. And we have done focus groups of other state agencies that don't have HR functions within there, and employees do say, we have this person to do it, but that person is my boss, or that
Sure,
person
that
is my
doesn't
boss's
work.
boss,
Right.
or this person's in another department, and I wish we had a more objective ombudsman or somebody in order to address those concerns too. So that is something I think you all have to grapple with.
We start to grapple with it in the new policy, but I think that as time goes along, it will be more refined, even than the new policy perhaps would be. But that definitely, I think, is part of the issue there. The other thing that I think you found that I thought was interesting was the culture.
Mm-hmm.
That a lot of people are interested that the issue is more of a cultural thing than a policy. And I agree with that, and we've had discussions about that in the committee.
Yeah.
Is it more of a cultural issue of a variety of things that you bring up, right? Whether that be discrimination or sexual harassment or conduct unbecoming to members or the staff. And how we address that and how we change that culture
Yes.
is going to be very important in the future.
And one that really needs to be grappled with, because you can change culture every couple of years, with the turnover in leadership and turnover and even the way people move around their offices right now, all that changes. And so it really has to be established as an organizational tradition, an organizational, if you will, understanding that this isn't going to be tolerated.
It's not one and done.
Yeah, it's not one and done.
And Representative Israel, this is a working group. We're not running like a committee. You're welcome to say and do whatever you want to do here. We're all just chiming in. You don't even have to be recognized. You can say.
I'm just curious and supportive.
Yeah, thank you. Thank you very much for that.
Thank you.
And I want to ask you, I was surprised to find out that all these surveys are being done of our state agencies. I was not aware of it. And so I am curious if you have anything you can say in general about maybe some of the state agencies that you have surveyed in regard to sexual harassment. If you've seen, we're talking here about how do you change the culture, how do you give people the confidence that the policies are meaningful without having to experience the harassment, how do you be proactive? Do you have any examples of anything that's been done that you have seen change? Well,
and to your point, because we have been in the past, and we have been able to survey every state agency primarily in about 200,000+ employees. We do have that same type of item that harassment's not tolerated in my workplace. It doesn't mean that they're being harassed, but it does mean that whether or not it's tolerated, or whether or not they feel as though the culture would support that kind of harassment to occur. And the agencies really vary. We have some agencies that 100%, and you'd want every agency to do this, but 100% of the employees feel as though harassment's not an issue. So a lot of the smaller agencies, when you get into the larger agencies, you have a bigger sample, you have a regression to means, there's lots of reasons, there's lots more people. Those larger agencies might have components that score really high on that, and other ones might be a little bit less. And so it is something, though, that the work that we've been able to do in the past with the state is kind of provide a bellwether, try to provide some information to agencies to address concerns. And we provide that back to the agencies, and they get that back in their reports as well.
So we have some other people that are going to testify. We're going to try to get through by noon today. Don't want to discourage anybody from talking and asking questions or saying anything, but do you have anything else right now before we move on to the next person?
No, but we would like to recognize your intern. What was his name? I'm sorry.
Daniel Shea.
Daniel?
Yes.
Stand up. So we
Thank
can
you, Daniel,
recognize
for
you.
your
Thank you, Daniel,
work
your
and for helping us with
participation.
this.
And he's leaving us
Thank you.
because all of our graduate students leave us at the end of the semester and go do his placement. And his placement's with HHSC.
Oh, good.
So,
Yeah, that's great.
and if there are any other questions afterwards, you have my contact information. Please feel free to just let us know. We'd be happy to serve.
Thank you very much. We
Thank you.
appreciate it. Thank you. So, next, we were going to hear from Chris Kaiser with Texas Association Against Sexual Assault. Thank you for being here, Chris. And if you, again, it's informal, but let everybody know who you are and what you're with.
Sure. My name is Chris Kaiser. I'm the Director of Public Policy and General Counsel of the Texas Association Against Sexual Assault. Thank you for having us here this morning. TASA is the unifying voice to eliminate sexual violence in Texas. As the statewide coalition of rape crisis centers, advocates, and survivors, we are committed to fostering a culture in Texas that respects the fundamental rights and dignity of all Texans. We want to sincerely thank this work group for the thoughtfulness and care that you've put into some really sensitive and complex issues over the interim. From where we stand, it's been really exemplary, and we really appreciate that. Thanks also to the Speaker's Office for convening this work group. I want to begin by emphasizing, before we get into the policy, just some maybe more just a philosophical statement about sexual harassment. When we tolerate sexual harassment, we're also tolerating an interference with equal employment opportunities for individuals, and particularly women and gender nonconforming individuals, right? That's true, but we're also tolerating this artificial drain on talent and skills that those people would bring for the greater good. So I just want to make sure that we recognize that in depriving individuals of these employment opportunities, we're also depriving ourselves of a broader benefit. When we don't allow this conduct to continue in workplaces, we all derive a benefit. That said, we're here today primarily to offer comments on the draft policy. I'm going to group these remarks into two main groups, but before I say that, I want to also say I'm lucky that I got to follow Dr. Landit. I think some of our recommendations are going to be fairly consistent with what he said. And I also want to qualify that we aren't privy to a lot of the conversations that you all have had as a group. So to the extent we're offering comments or suggestions, we acknowledge that may be some things that you've considered already and had discussions about.
Yeah, let me just make sure we all remember that we haven't shared any of these draft recommendations along the way. So you're coming, Chris, are you not, from the policy that we created in December?
I believe so.
Yeah, so
your staff had
it's hard
forwarded. Yeah.
we haven't put anything out there yet, so it's hard to know exactly. So I appreciate your comments that some of these things we may have already talked about, but.
And Chris, you may want to stick around until after. We want to hear from you right now, but
Sure.
to hear the comments that our attorney is going to say at the end, and then hear the discussion with that, because you may want to add some additional comments to the public record after you've heard about the new policy a little bit.
Absolutely,
Thank you.
I appreciate that.
Thank you.
So as I said, I'm going to group my comments on the draft policy into two main headings. First, we just wanted to highlight some provisions that we felt were either particularly strong or maybe could use some improvement or clarification. And second, we wanted to say a few words on what we believe has probably been the more challenging issue that this work group has considered, which is how to handle allegations against elected officials who aren't employees of the House, right? So with that said, substantive comments on the draft policy. The positive highlights, I think, really strong, clear statement against retaliation. As you just heard from the previous witness, threats of retaliation or a perceived risk of retaliation is probably the biggest reasons that people don't come forward. And we felt like the statement against retaliation was very clear, very conspicuous in the policy, and that goes a long way. Likewise, there is strong language protecting the privacy of complainants to the greatest extent permissible by law, as well as the provision of interim steps to support and protect complainants when they do come forward during the pendency of the investigation. We felt like those three provisions, being as clear as they are, go a long way to address, at least in the written policy, what a lot of complainants have on their minds and what might militate against coming forward about this stuff. We also appreciated that there's a provision to use outside investigators rather than just committee staff to do this if there's a risk of bias or partiality. Although we will say, I think the phrase was if necessary in the draft policy, and we wanted to just raise the possibility of maybe fleshing out when that might be necessary. We weren't sure if that implied that the usual case is that it's not necessary. Given the broad concern about potential retaliation, we felt like the best practice might just be to use some external investigators. Some opportunities for improvement, potentially. First, I think you heard this gestured toward by the previous witness, too. The draft policy covers House employees and interns. There's nothing that explicitly protects other folks who are outside the Capitol but here on the regular course of business. So people like press, lobbyists, folks from advocacy organizations. Just as a point of comparison, the Senate's new policy expressly covers people whose work requires them to visit the Capitol on a regular basis. I think we've all heard stories of people in that position who feel particularly vulnerable and don't necessarily feel like they have a place to go. So we would recommend including something along those lines to cover those folks. Second, we felt like it could be useful to include some kind of timeline for when these complaints would be resolved. It doesn't necessarily need to be a rigid timeline. We realize that case by case these could be more complicated or less, but we know that the Capitol's a really busy place. It's never going to be an ideal time to address this kind of thing, and we just think that the policy shouldn't allow for any room for delays or unnecessary deferrals. Again, as a point of comparison, and I'm not sure if this would solve it, I think it would go a long way, though. In the Senate policy, there's a provision that provides that it's an unlawful employment action for an employer or agent of the employer who knows or should have known about sexual harassment to fail to take immediate corrective action. So maybe just a reference to immediate action once you know or should have known about harassment would be enough to provide some assurance of prompt action. Before I move on to the elected official issue, I wanted to pause and just ask if there was room for additional discussion of any of those comments.
We have considered several of those things, so we'll hear that when we hear from council, but
I expect
thank
so.
you for that, yes.
Sure. So regarding misconduct or alleged misconduct by elected officials, obviously a standard employment policy makes all the sense in the world for almost everyone at the Capitol, right? But it's just unclear how your typical employment-related sanctions would cover somebody who's not an employee of the House, who's here at the pleasure of their constituents, right? And so when the draft policy makes reference to adverse employment actions or appropriate sanctions, we're just not clear, and we expect that employees or people subject to harassment would also be unclear about what sanctions or remedy to even expect. And so on this point, we just wanted to offer, and this very well, again, may be something that you all have already considered, we wanted to offer that it just seems like there's a fundamental incongruity in trying to cover what really amounts to official misconduct with a purely labor-related policy. House administration, the payroll department, all that is absolutely the appropriate entity to handle House employment matters. But when the alleged harassment is alleged to have been committed by an elected official, it takes on these elements of official misconduct and abuse of office and things like that. And so given that, we wanted to raise the possibility that maybe for this unique set of allegations, referral to someplace like the Committee on General Investigation and Ethics makes more sense. That committee has jurisdiction over, quote, official misconduct, malfeasance, abuse of office, or incompetency, and has authority given to it to propose sanctions, including proposing articles of impeachment. It would just seem that the unique character of this set of allegations is really closely aligned with the purposes and functions of that committee, and we were just curious to know whether, if at all, you all have considered that approach. In any case, we think describing some clear and reliable approach to holding all people accountable for this misconduct is really crucial. As I think you've already heard this morning, there has to be some confidence that something can happen to put an end to the conduct, but also to keep somebody's job safe if they do decide to come forward. Harassment and abuse, sexual or otherwise, thrives in environments where certain people know that they're above the law and their victims know it too, right? So an environment that does not tolerate that's free of harassment, is one that demonstrates through words and actions when allegations come forward that the consequences for this misconduct apply to everybody. So that concludes my prepared remarks. I really thank you for involving us in this process, and just please know that as you go forward, we're here to help in any way that you deem appropriate.
Thank you, Chris, and I'm very pleased to say that I think we did address, maybe not with the exact solution, but we did address everything you brought up, and if you can hear what that is later on, or we can certainly share it with you too, but that's exactly the kind of thing we wanted to know is, are we going in the right direction, and if there's anything we need to be doing differently now. But anybody want to ask him anything?
I don't want to ask anything. I just want to point out that, yes, it is gratifying to hear you point out some of the things that we've been having discussions about through our conference calls. These are things that are important to the task force, and obviously through your knowledge, you verified that. So that's kind of what we needed to know. Were we on the right path? Were we doing, those things that we needed to be doing in order to clarify the policy, in order to send it on its way to private counsel or a different committee? Those are the kinds of discussions we've been having. So it's been very helpful to listen to you because you have a broad range of knowledge. So thank you for coming. I really appreciate that.
Thanks.
And we may want to ask for comments afterwards,
Yeah,
for him
maybe.
to submit comments afterwards,
Yeah.
after you see the policy. Yeah.
Sure. Anybody else? Thank you, Chris.
Thank you.
Appreciate it.
Chris.
And so now we will ask Barry Rosenbluth, is that how you say it? And Sandra Molinari from the Safe Alliance, stop of use for everyone to come up. And again, as I keep saying, this is informal, but please introduce yourselves and your organization, and then just let us hear what you have to say.
Good morning. My name is Sandra Molinari, and I am the Community Education Director at the Safe Alliance. Safe Alliance is a merger of Safe Place and Austin Children's Shelter, and we work with people who've experienced sexual assault and exploitation, child abuse and neglect, and domestic and sexual violence in a number of ways.
Thank you for your good work.
Thank you.
Good morning. My name is Barry Rosenbluth, and I am the Senior Director of the Expect Respect program, a program of the Safe Alliance. I work with schools on creating safer and more respectful environments for students by addressing bullying and sexual harassment, dating abuse and sexual assault, and creating environments where these behaviors are less likely to occur. So thank you for having us this morning, and we
Thank
hope
you.
our
Thank you
comments
for
will be
your good
helpful.
So we're here to give a little bit of input on the current policy and how it could be strengthened. But Barry will speak to that in a moment and give some supportive commentary on creating a safe, respectful environment here at the legislature. In my role as the Director of Community Education, we work with the community to create safe and respectful workplaces and spaces in general. And we have created a number of trainings on creating those safe workplaces, namely preventing sexual harassment. We've done this with mid-sized companies and a number of other organizations throughout Austin. Our focus is on preventing sexual harassment and going beyond compliance. So a lot of companies will do compliance trainings, and it's really kind of a check-the-box thing. This is okay, this is not. So we talk about what are behaviors that are actually acceptable, what are behaviors and values that employees can show in their organizations that will keep the environment safe and prevent the harassment. And if there is harassment or there are problematic behaviors going on, how can others step in as bystanders to interrupt those behaviors? So I'll talk a little bit about that in a moment.
Okay. We've organized our feedback on the House policy into 5 major recommendations. The first of these is, we suggest, aiming to create the civil and respectful environment, going beyond a more narrowly defined sexual harassment policy, but really looking to promote the behaviors of civility and respect that you want to encourage. Some sort of a code of conduct would be one way to do this. Articulating your values and the positive behaviors that you expect in the workplace, and also among everyone to stand up for each other's rights to be in a safe environment. I'm just going to summarize the comments here, but we've provided some more detailed feedback about the policy previously. The second of our recommendations is really make it easier for targets and bystanders to report incidents. This can be done in different ways. Consider using an online reporting system that prompts the user to document immediate and relevant details, such as what happened, the time and date, who did you tell, how did it make you feel. There are online services that can provide this, or you can create your own. It may allow for anonymous reporting, which can help supervisors identify problematic areas. And also doesn't focus narrowly on sexual harassment, but all forms of harassment and disrespect in the workplace.
Barry, sorry, since you mentioned that, sorry, Celia. That was my point in the beginning. Why isn't your group called sexual harassment? That's your group. Everything that you talked about dealt with unbecoming behavior. You talked about safe working environment. Your group is called SAFE. So why did you choose not to be called We're Against Sexual Harassment?
Well, all of these behaviors are related and often occur simultaneously. And they all have the same impact in making the environment hostile, unproductive, and one that's conducive to more serious forms of abuse and assault to occur.
So my point is it would you do you agree that, I guess Noelle said, make your questions in the agreement form. Would you agree that a code of conduct is what you said, a code of conduct would be, appropriate to change the title to like a Workplace Safety Act or, something that dealt with safety, workplace safety, to make it more broad and inclusive, that way encouraging more reporting, if that's what our goal is, so that way it's just not sexual harassment. Barry, is that what you're suggesting, or is that something that you're leaning towards? So that way we're not just saying it's all sexual harassment, because then some people may say, well, this is not sexual harassment, or it could be, and then
Exactly.
some men may think sexual harassment is geared towards them,
I think it's worthy
and
to
it's not.
consider addressing the full range of behaviors that are considered harassment and abuse.
Exactly. Okay, so that's what I was thinking. Okay.
Sorry, go ahead.
I'm intrigued by the nature of it, of something called a code of conduct, because I think that'd be pretty cool, actually. I mean, we're accountable to the voters, but it puts an extra level of accountability on how we do the business of the people. And you have a URL here from Capital Factory, Code of Conduct. Is that an example of language or technology or both?
It's an example of language that we like, and also you can just click here to report any unwanted or inappropriate behavior in the workplace. So it makes it very easy to submit a complaint.
Mm-hmm.
I assume they have some kind of centralized HR that would receive that.
I wouldn't
Complaint.
know, but
Okay.
we think it's a model document.
Okay, thank you.
I've one more under making it easier for targets and bystanders to document and report. Is that we felt it was unnecessary to include confronting the harasser in the policy. We think that's a training issue. We think that belongs in a code of conduct, but not necessarily in a policy. And that the policy.
Ask one question. I'm sorry to back up Representative Israel's comment. Under your website here, if you click on this and it says Code of Conduct, then does that take you, I'm sorry, I must have missed it. Does that take you to a reporting site as well? Or does that just take you to what the Code of Conduct should be?
It takes you to the Code of Conduct, and then there's a link within the Code of Conduct that says if you're experiencing any unwanted, inappropriate behavior,
Gotcha. Okay.
click here.
Gotcha. Okay. Thank you. Sorry to interrupt.
We're concerned that including the text that suggestion to confront the harasser in the policy may create an extra hurdle for targets who don't feel safe, who don't feel comfortable. Although we recognize it's worded very much as your choice, we think that that can be perceived by some as an extra barrier. We think this language about what is expected should be in the training and should be in a code of conduct. And then once you've been a victim of harassment, that the policy should state how to file a complaint. The third recommendation is, as we've heard from others who testified, ensure independent oversight of the complaints. We're concerned about the conflict of interest that appears to exist when legislators are expected to police each other.
Only we could.
The fourth recommendation would be to provide additional training. The fourth is to provide additional training on workplace civility and bystander intervention, and we've included reference to the EEOC Training Institute, which recommends both training for all employees, but then also a specialized coaching model for supervisors. That would advise them on how to respond effectively to a complaint, but also how to coach employees who need more support and education and training on appropriate behavior. And finally, the fifth area is to expand resources. Your reference to counseling for targets, we would suggest expanding to resources for people who experience harassment, which go beyond counseling, to organizations that offer a full range of victim services and supports. Yes.
I just would add around the counseling. The idea of saying counseling as opposed to resources assumes that a person who's a target of harassment is the person with the problem and needs to seek help. It's kind of, I fear that it could be perceived that way, whereas a victim of harassment may not need counseling. They would just like to seek redress. So that was why resources instead.
So, any questions or further discussion on any of those?
When you suggested providing additional in-person training, what kind of in-person training, if you could be a little more specific on that?
There are models provided by the EEOC. They provide the training. There's also an outline of that training. SAFE can develop and provide training along those guidelines, as well as probably other providers in the community. But this would be an experiential, in-person training for people to identify the forms of harassment that impair the workplace. And what they can do about it, and their responsibility to speak up, to confront someone, to say that's not okay, we don't do that here, we don't say that. To make this more of a shared commitment of employees to maintain a safe environment rather than putting the burden on the victim to only to file a complaint.
Thank you.
And what we've found in our trainings is that when we have people in the room together talking about these behaviors and what's problematic and what is good behavior, what is respectful behavior, is we find that when we engage people in activities around speaking up around what they've experienced before or what they would wish would have happened, we have an activity where we ask people to step in if they've experienced X, Y, or Z. And we ask, for example, have you ever been in a situation where you wish somebody would have stepped up? And we usually get at least 2/3 of the group that steps up, meaning, yes, I've been in that position. And what that might tell others, and we discuss this, is kind of the bystander piece. If you see something that seems off and you're not sure, go check with that person, see if they're okay. Don't necessarily jump in and try to save the day, but go see the person who you perceive to be maybe a target of harassment and ask them, is there something wrong? You know, I just saw something that did... Because that target, if everybody else is silent, may feel like I'm over. I don't know if I should say something. How am I going to be perceived? Whereas having a witness step up and say, "I saw that. That didn't seem right. How do you feel about that?" makes a world of impact and might empower that person to step up and say, "This happened to me." So conversations like those can't happen if we're having simply compliance trainings or online trainings or just a person talking at a group. So those are some of the things we've found as well.
So one of the things we're considering, so that you'll know this and you'll hear this a little bit later on, is not only the compliance training, as you know, which is online, but also if you choose to do so, you can have live sessions, live training, perhaps you and your staff, and put you in situations where that they have to make decisions, and it's pretty similar to what you're saying. So, how in your view, and I know you do this as a training model, but in your view, do most big corporations do that, or do they not do that? How does that work?
Honestly, I'm not sure what most big corporations do. I couldn't tell you that. In the experience that we've had, it's been successful in getting people to talk to each other in corporations, in mid-sized corporations, and other types of organizations.
So they're calling you in as
Yes.
as the trainer,
Yes.
right? Okay. And that is your function a lot of the time,
That is the function of myself and some members of my team.
right? And I know you're mostly in the schools, and we appreciate that. Okay.
And we do that with faculty training.
Oh, okay. Thank you.
We all also going to go into some recommendations?
Yes.
then? Okay.
So some recommendations on creating a safe work environment are, and you have these remarks in front of you. All of the best practices indicate that the most important thing that an organization can do is to make change from the top. It needs to start with leadership, and Barry's spoken a little bit to the idea of the code of conduct, which really lays out what an organization's values are. And again, the code of conduct that she referenced of Capital Factories are really good examples. But it's important that leadership model respect and civility because it starts from the top on down. And so that change really needs to start at the top. Again, it's fine for employees to be talking about what's a helpful, a respectful, safe environment. But if it's perceived that the people in leadership aren't respecting that, then what kind of message is being given? Kind of this, the leadership need to be role models. We've talked about this, but I'll mention it again. The best practices state having a policy that accounts for the confidentiality, provides clear mechanisms for reporting safely, protections against retaliation for both victims and witnesses, and holds perpetrators accountable regardless of their status. Again, that's very important. Reviewing the policy regularly is also very important. Is this working? I know Noel spoke to surveys, also climate surveys, which are also very helpful. The climate surveys and seeing what's working and what are the gaps in the response to the policy. Is the policy working? Are people feeling safe in reporting? And if not, then reevaluating what's not working. We also recommend, and again, this comes from best practices, reevaluating the performance review process. So in a lot of companies, we are looking primarily at hard skills, what makes a strong performer, soft skills as well, but are we also considering those behavioral skills, I should say? Are we evaluating how well people are behaving with their coworkers, how they're being treated, whether they're being respectful? So the review process, that's important because too often, and we've seen this a lot, especially in the last year or so with the Me Too movement, hearing about all of these perpetrators of sexual harassment or assault who were not let go for a long time or not even investigated simply because they were doing their job well on all other fronts. So this needs to be taken into account as well. And we recommend providing in-person interactive sexual harassment training, as we've talked about just now. Empowering bystanders is extremely important in offering them training because really, again, it shouldn't be simply on the responsibility of the target of the harassment to speak up. We've heard from several people today around why that is difficult to do, why it can be unsafe to do. So we need people stepping in. And we need people to feel that they'll be supported if they're stepping in, and we need people to have the tools to step in. So that can be, I want to specify that that's not just stepping in the moment of harassment, which is extremely important, of course. If, I don't know, if I see somebody being touched inappropriately, it would be important to step in. But it's much, much earlier than that. It's the inappropriate gestures, comments, jokes that are part of so many workplaces. It's the jokes in the break room that are demeaning to different groups of people, that allow a culture of lack of respect and civility, and a culture that is actually very unsafe for people, and that it still exists in so many of our organizations and our companies, including our nonprofit organizations sometimes today. And that makes a breeding ground for harassment to happen and to be allowed to continue. That's very, very important around changing the culture and empowering bystanders. Finally, and I don't think this is a surprise to any of you, the studies show that we need to close gender equity gaps. When there is better gender equity, there is less harassment of any kind. I don't think that's too difficult to understand. That concludes our prepared remarks, I think. I don't know if you have further questions or comments.
I guess
Thank
not.
you, ladies.
Yeah, thank y'all very
Yeah,
much for
very,
taking the
very
time. This is
Thank
very,
you.
very informative. We appreciate it.
Thank you all.
Thank you. So now we'll get down to John Schnauz
Yeah,
coming
John.
up and hear where we are right now with our draft recommendations and what further work we might need to do.
While John's coming up here, we want to thank him for his service to our committee, obviously his service to the state of Texas. But for those of you that are just watching casually on television right now, John has really done the yeoman's work on getting us right down the good legal path on this new policy. So John, thank you, and done a lot of research on it. So
Thank you. It's been my
we
pleasure.
appreciate you.
Co-chairs Howard and Coop, members of the work group, good morning. As was said, my name is John Schnautz. I serve as general counsel to the Speaker. In that role, the Speaker asked me, along with other members of our staff, to assist the work group in its charge to recommend additional changes to the House's sexual harassment policies. I'd like to begin by offering some historical and practical context for the policy. The House has had a sexual harassment policy applicable to members and employees since the 1990s. As regards House members, the legal basis for this policy is grounded in the Texas Constitution, specifically Article 3, Section 11, which allows that each House may determine the rules of its own proceedings and punish members for disorderly conduct. And that provision is basically the hook for any and all sanctions that the House might choose to impose on its own members for violations of any provisions of the House rules. And in analogous provisions in the House rules. Up until last year, the policy had been changed little during the roughly 25 years it had been in effect. It generally consisted of a statement that sexual harassment was not tolerated, a general description of the legal standards for sexual harassment, a general description of how to file complaints, and a reference to the outside governmental entities, Equal Employment Opportunity Commission and the Texas Workforce Commission at present, with which complaints can be filed. This policy was readopted every 2 years, as some of you who've sat on the Committee on House Administration know, by the Committee on House Administration. That was done as part of that committee's biennial review of the House Personnel Manual. And that manual, as you'll have probably seen, is several hundred pages long. It includes everything from guidelines for expenditures in offices to House photography to rules and policies like this one. That review and revision process of the personnel manual typically occurs in early March of each session year. In early December of last year, in light of the increased scrutiny on sexual harassment policies in legislatures around the country and in other settings, of course, the Committee on House Administration took the unprecedented step of modifying the policy outside of that regular biennial readoption schedule that I described. I want to briefly overview the most significant changes that were made at that time, almost a year ago now. One of them was a requirement for the first time that all House members, employees, and interns take a sexual harassment training course. There was a date certain established for that. Once that date passed, it was 30 days after the beginning of employment or service and every 2 years thereafter. Stronger language was added to the policy prohibiting retaliation against those who file complaints, also against witnesses. There was more specificity in the policy on how complaints may be filed and on possible sanctions for violations of the policy. Additional language was added protecting the confidentiality of victims and witnesses to the extent possible. The policy was applied to interns. That was not covered previously. Examples were added to the policy of different conduct that can constitute harassment potentially or a violation of the policy. And then, in addition, an issue that's come up before, the policy before and at present is denominated as a sexual harassment policy. There was a reference in it that other types of harassment based on protected classes was also covered, but it was a little bit buried in the way the policy was drawn up, so that's been made more explicit in the changes made last year. And finally, information was added about outside counseling resources available. And just to be clear, I know the work group understands this, but just to be clear to anyone else that's listening, that's a description of the changes that were made last December. Kind of takes us up to where we are at the present. And then given the continued interest in the topic, of course, Speaker Strauss in May appointed this work group to recommend further improvements to the process that we're going through now. The work group's authority, just to make it clear, and one of the reasons that it can be organized as a work group is that it only goes to making recommendations that someone is going to have to take the next step to actually make into policy. And one of the issues, of course, that the work group is going to have to decide is how it would recommend that its recommendations be acted on. Specifically, and we can go into detail if y'all would like, but specifically the options are some sort of consideration before the full House, which to my knowledge, unless it happened back in the historical record when this policy was first adopted, that's possible. But since then, this has really been in the purview of the Committee on House Administration and hasn't been changed very much, obviously. So those are the two general options. With that context regarding our own policy in mind, I want to briefly touch on the national context in which this review is occurring, specific only to state legislatures, not everything in the country. But as probably you would assume, goes without saying, Texas is not the only state that's undertaking a review of its harassment policies. There are probably far fewer that are not than that are. While not comprehensive, I've prepared a few statistics on the scale of the issue in legislatures around the country. To give credit where credit is due, these were actually compiled by John Heining with the Legislative Council for a presentation that he did. Based on public accounts and then some additional research to kind of validate whether they should be counted in this or not, there have been 49 incidences around the country in which a state legislator was subject to some formal sanction or reprimand as a result of sexual misconduct with some connection to his or her legislative service during the period between January of 2017 and a few weeks ago, mid-October of 2018. The punishments imposed have ranged from requirements for additional training, fine, removal from chamber or committee leadership or committee membership entirely, public reprimands, all the way up to the most extreme sanction that is available in this setting, which is expulsion from the legislative body. During that period, January 2017 to roughly a month ago, there have been 2 actual expulsions of members, one of which we've provided some detail for the work group on, just to kind of give you all a sense of how that process looks. One was in Arizona, the other was in Colorado. In addition to that, and I think this is a really important practical point to keep in mind, people tend to focus on expulsion. In that entire period, there were an additional 24 members who resigned from office either before, during, or after investigations. And I point that out, just, that effectively ends the legislative body's authority to impose any other sanction. And people tend to, with good reason, sort of get hung up on the process for expulsion and the very dramatic cases in which that's actually happened. Those numbers suggest that in most cases, when a member thinks that expulsion is a pretty strong possibility, they opt out on their own, 24 resignations versus 2 where it actually came as far as a vote for expulsion. With that context in place, I would now like to provide a general overview of the most significant points that we as staff have noted in reviewing other policies from around the country, as well as looking at the internal and external observations that have been offered about the House's current policy, both the ones today to the extent I can, and then also what we've looked at over the last several months. One of the issues that's been raised today and that comes up most often is the scope of the policy in regard to those who are not members, employees, or interns of the House. And I tend to refer to that as sort of outside the employment tree of the House of Representatives. The current policy was adopted in large part in recognition of the House's duty as an employer to prevent workplace harassment and discrimination. And so it is focused entirely on almost entirely on people within that employment tree. However, there has been interest expressed in a broader policy that would be applicable to others who interact with the House. And when I say applicable, I mean on both ends, both as potential targets of harassment and also as potential offenders. Another big picture issue, somewhat similar, relates to the scope of conduct that is covered by the policy. The intent of the current policy, the one in effect now from last December, as I think would be the case with any strong anti-harassment policy, is to prohibit harassing conduct, even if it's not also illegal. And the reason for that, among others, is a good policy is designed to prevent harassment from ever getting so bad that it violates the law. And if the only things that violate your policy are things that would already violate the law, you're sort of stuck in a position where you have a difficult time doing anything about it that's not voluntary up until someone crosses that line. The intent of the policy is already to go there. However, the policy could be a little more clear about this, and strong suggestion that it should be, and also provide some additional examples of impermissible conduct and try to kind of define that scope a little better. In addition, another issue that's come up, particularly on the survey responses, while the revisions last December added a lot of detail to the investigation process, it is also possible to provide more detail on that process. And that seemed to somewhat come out on the survey findings. When you leave some things undefined about the investigation, people can sort of fill those in with their own kind of worst case ideas about, well, what if they do it this way, or who are they going to have investigate this, all those sorts of things. You could cover issues, for example, such as when outside investigators would be used, the content of investigation reports, the entities that would receive those reports and be expected to act on them. That's not extremely clearly defined in the policy as is. And as I've said, lack of clarity on those points can help feed into a perception that the process may not be fair. The current policy also doesn't include any specific language regarding false reports or statements in the course of investigation. Many of the other policies around the country do. The balance to be struck there that's really careful is you don't want to say anything in that section of the policy that discourages people further from reporting things that are truthful. So you want to make it very clear. We're not talking about a factually accurate allegation that simply doesn't rise to a violation of the policy or the law. That's not what this is about. This is about the unfortunate reality that any complaint process, someone could potentially try to abuse it by filing a false complaint. That's just a reality. This is a particularly acute issue if the policy does expand to cover potentially the entire world in terms of people who are in some way interacting with the legislative business. You want to make it clear to everyone that this policy is supposed to be about good faith, accurate reporting, and not to be used for any other purpose with that balance. Finally, I want to touch on a few other issues that are less directly related to the policy's language, but that are related issues in the broader context of preventing harassment. One of those is records retention. That hasn't come up today, but there was some press accounting of it during the course of the work group's work. I don't want to get into the details of records retention too much, or I'll put everybody to sleep. But under the current House records retention schedule, in brief, complaints of this sort that result in disciplinary action would be subject to a longer retention period. In other words, how long do those records stay around versus complaints that don't result in a disciplinary action. And the potential there is that you could have a series of complaints filed that are filed but that don't actually result in anything being done, and then someone comes along later and gets another complaint and doesn't realize that those complaints ever happened because they're not there anymore, and that's perfectly legal. They didn't have to be. Those periods could be aligned so that basically any complaint would be kept for the same amount of time. And on the disciplinary action side, the retention period is 5 years after someone leaves this place. So for an employee or a member, it sticks around for 5 years after they are no longer here. And that is much more likely to ensure that whatever exists out there in the records, that nothing was destroyed during a period where someone could have recognized some pattern of behavior that could otherwise be uncovered. I do want to say, those recommendations, the House Records Retention Schedule is actually supposed to be regularly revised next year anyway. Those changes would then have to be approved by the State Library and Archives. That's the way that process works statutorily, but that is a recommendation that could be made to cover that issue. An additional area is training. Y'all have heard a little bit about that topic today. So I would only mention that, more interactive training, including live training, that is an option that's available. and that I think the experts would tell you is generally more effective than online training alone. My suspicion is that the House's structure, just the way we're organized, fairly large, fairly diffuse workforce, people coming on and off the payroll with some regularity, some kind of online training is probably going to be necessary on the front end. But that need not be the only type of training that's available or that's encouraged. There's no reason we can't do more than that, and that's an area the work group could touch on. And then a final related issue that's been raised in many states and in Congress is the potential for abuse of claims settlements, particularly in regard to confidentiality clauses. And I have some detail on that if y'all are interested. Briefly, there are already statutory and House rule provisions that limit the availability of formally, legally enforceable settlements of this type involving the House. However, what the workgroup could do is consider making it clear that state funds also couldn't be used for what I would term informal settlements. To use an example, say a member is accused of harassment by his or her staff and says, okay, don't file that complaint and I'll give you a $500 a month raise. I don't think that's a legally enforceable agreement anyway, and it's something that someone should already realize they shouldn't be doing. But putting something on the personnel action form, for example, that just makes it clear you can't use salary changes or anything to try to effectuate any kind of informal settlement, it's just an additional measure to bring that to people's attention. Congress has considered something similar. I don't know if they've ever actually passed it, but it's a worthwhile idea to consider. And the final comment I want to make to touch on an issue that's already come up relates to the limits of what policy changes can do. I am not an expert on organizational culture of any type. What I would tell the work group is that after spending many hours looking at other policies from around the country, gathering other available information, looking at the results of our own employee survey, it is impossible not to recognize the overarching critical role that organizational culture plays in the realization of a safe and respectful work environment. A strong and robustly enforced policy is a necessary step in that, but it is only one step. To the question of, y'all's charge obviously is to recommend changes to the policy. So is it as much as, well, we can do as much as we can in the policy, but organizational culture, what do we do? It's not a throw up your hands situation for a few reasons that I think what I've already said had made clear, but just to bring them home a little more, just the existence of this work group alone, I think is a step far beyond what's been done for the duration of the time that we've had a policy. I mean, there's been several orders of magnitude more activity on this policy in the last 12 months than there have been in the last 25 years. That's not to say that's the end of the road, but in terms of the leadership commitment and in terms of showing the House's commitment to bringing this forward. For example, also if the work group's eventual direction was to recommend this really needs to go before the whole body, that's something that, to my knowledge, hasn't been done before either. Prior to last December, I don't know what percentage of our employees, frankly, knew that there was a sexual harassment policy somewhere in the personnel manual, or for that matter, maybe members. It just wasn't an issue that was as top of mind as it is now, obviously. And so I wouldn't diminish the role that changes to the policy can make and that y'all's leadership can make in carrying this forward. So I don't think it's a hopeless situation by any means, although organizational culture is a hard thing to change. That is all I have to say, and I would now be happy to answer any questions that you all may have.
John, thank you so much for all your work on this, and just so we're all clear, and feel free to chime in here, but just so we're clear on where we are now with the draft and where we want to be. We want to be able to have something ready to submit to the Speaker and to other House members by the first week of December. So what you're talking, what the things you just laid out right now, those are being worked on to be incorporated into that final proposed draft that we will agree or not agree to as a group?
Correct.
Okay, so,
And I should say, just in addition to any other feedback following this hearing, additional areas that have come up that y'all want us to focus on, the time is relatively short to meet that deadline, but it's still doable.
let me just ask real quickly though, too, in terms of just logistics with the records retention and TSLAC. So they have rulemaking authority, or what is it we're talking about there?
I believe this is accurate. I can follow up more specifically, but the general process is the House can't unilaterally change its records retention policy, even if we are expanding the scope of how long things are going to be retained, which is what that change would do. You still have to get TSLAC's final approval. I don't know how long that process takes, but I will say I don't think it would take so long that it would actually make a difference in terms of what's being retained. In other words, by the time the current records retention schedule would have run anyway,
Something new could be put in place. to
something
extend
right,
it.
and it would be you'd keep it longer beyond that, but we wouldn't get to the end of the records retention schedule and say, well, the schedule says destroy it. I can't imagine TSLAC would take that long.
So we would, if we chose to follow through with what you're suggesting here, we would get all the records to be retained for 5 years post-employment, as opposed to some that are retained for a much smaller period of time. That's the recommendation?
As to complaint records,
As
right?
to
I think
complaint
the
records.
specific category is grievance records or something along those
Okay.
lines, which includes more than just this. But basically that all of those would be held for 5 years past whoever is a subject of the grievance leaving this building.
So that would be a recommendation made that would not be a part of our policy, but a recommendation that we would make
Correct.
to the speaker and to other members.
Exactly. And as I said, the retention schedule is being revised next year anyway. I don't know if there'll be any other changes proposed, but that recommendation could be incorporated into that.
I just have a clarification question. Are you talking about complaints with merit or both merit or without?
I'd have to look at how the grievance record series is defined. I don't know if a complaint that was just dismissed because there was found to be no basis for it whatsoever. I mean, there's already a record series for that and already a records retention requirement for it. We're really just talking about changing the time period. My guess is you would keep them all for the same period of time, but the record in that case is also going to reflect that the complaint was groundless or didn't have a basis or whatever the final disposition of it was.
I'm glad you brought that up, because I want to say that, not being a lawyer, I may use the wrong terminology here, but my understanding from what was shown to me recently in regard to the Texas Workforce Commission, which does issue a report on these kinds of things, that less than 2% have a finding of cause. Is that the right terminology? So apparently the burden of proof is very difficult. I'm, again, not a lawyer, but I understand this is the case, so that we have many more complaints than we actually have those findings. So it would be an important distinction, I think, to look at that, because it's obviously much more nuanced than the findings.
Well, yes. Well, I would agree with that, but then also my other concern would be, if you keep the records, then what else are they going to be used for? If somebody else says, oh, well, then I also said this, and then it could become a fishing expedition.
We're talking politics here, right?
Well,
Too?
yeah, somebody else could say, well, they also said this in this statement, and then they can use it for some other type of claim.
Right. And just to remember, we're not talking about changing anything except the duration with which they stay around. So to the extent that process could already be abused by people filing false grievances or manipulating grievances, all those sorts of things could be done now. They just wouldn't stay in the file for as long.
Okay, so if somebody has the record, I know the policy now that we have, the records deleted after so much time, right?
It would be, in the case of a grievance that doesn't result in disciplinary action, it would be 2 years after the investigation's concluded.
And so under the proposal, how long would they keep them?
5 years after the subject of the grievance leaves the house one way or the other, either employment or membership.
And we would not have the opportunity to make it compliant with what we have in our current policy. We could not make them line up. Like we could say, well, it needs to be the 2 years, just like we have it in the House.
I'm not sure I follow you.
Well, I mean, you're saying that if it's not a merit, if the claim doesn't have merit in the House right now, it's 2 years, right, after it leaves the House.
Well, it would be either, whether it has merit or not, if it doesn't result in what meets the definition of disciplinary action, which is some kind of, take an employee, demotion or termination or change of title, whatever the case may be, then it would kick into the longer. However, you could have a complaint that doesn't rise to that level but is still a meritorious complaint. It just doesn't result in the employee actually being disciplined. Maybe they're just sent to more training, some sort of corrective action. So it's not just complaints that aren't meritorious that aren't kept that long. It's everything that doesn't rise to the level of something where you actually take a disciplinary action against the person that's the subject.
So you're talking about like a statute of limitation part?
It's similar, but I mean, the records retention schedule is full of all those sorts of things. All of them have everything that's in the schedule has a period after a date certain with which it's supposed to be retained, and at the end of that retention period is supposed to be destroyed.
So, okay, so that, I guess that's why the one, once it goes to that organization, would be longer, because it protects the statute of limitation.
I don't know if there's any direct tie into statute of limitations, because in terms of the EEOC or workforce statutes, those are much shorter than what we're talking about here. Right. I think for what y'all would need to balance is it better to have what we have now, where you run, I think the criticism out there was you could have had 5 complaints 5 years ago against a sitting House member. To be clear, I'm not saying this is the case, because I don't think it was, but you could have had those on file. Let's say they were all made within a month's period. There was some sort of investigation. It was finished, but there just wasn't anything done about them, and then they're gone. And unless there's an employee who happens to have been around for a long time and remembers them, no one else might. And then you get another series of complaints involving that member, and it looks like, well, nothing's ever happened. This is strange. Whereas in reality, there is a record out there. You have to balance that possibility under our current retention schedule with the idea that, that even unmeritorious complaints are going to be kept around a little bit longer. And that's y'all's decision to make. I'm not saying there aren't risks on both sides of that, but there is a risk on the front side that you could potentially miss a pattern of behavior.
I see what you're saying.
Because it's just not there anymore. It's not supposed to be under the retention schedule.
I got you.
Yeah.
I've got another question. With regard to these records themselves, what is the current policy as to whether you can obtain them through a open records type of request? These are confidential records, correct?
Certain aspects of them are.
Okay.
The policy right now refers to protection of victims and witnesses' identity. So law enforcement investigations are a little bit different. Those have their own provisions for not confidentiality, but an exception under the Public Information Act. The exception that applies to this is basically the common law privacy exception, which the way it's been interpreted in the courts basically means that victims and witnesses get protection. The accused doesn't necessarily. And frankly, that's not something we can change by virtue of what we do in the policy.
So then it's redacting the records and then permitting some of them to be disclosed.
Right.
Okay. And there's current policy on that.
And I would say if there was an active investigation going on, I think you would have some other exceptions
Privileges.
available in terms of drafts and all sorts of things that you wouldn't have to release those records in the middle of an investigation, probably. At the end of the investigation, I think some of it probably would have to be. Unless there's an exception that I'm not thinking of.
So there's not any need to make any changes to that because that is already standing rules, procedures,
I
policies.
think the most I would say is you can't change that in this policy because
Okay.
that gets back to the Public Information Act and
Okay.
things that are statutory at least.
Okay.
John,
Thank-
would
thank
you summarize two of the issues that we've talked about and where we think we're going right now? One is how we're addressing so-called third parties that are not employees of the house, but that how we are talking about addressing that. And then secondly, how we're talking about addressing accusations that involve a member and how we're thinking we might go there in light of some of what we heard earlier about General Investigating Committee and that sort of thing.
So we have looked at a lot of policies that do apply to third parties on both sides, both as, again, as offenders and also as victims potentially. I don't, if there's a state out there that has a magic way to explain when that applies and when it doesn't, I haven't found it. I think, the issue for the work group to consider is once you sort of cross that line out of people that are in the employment structure of the house, well, then who's included? Is it the entire world in every interaction that a member or employee or an intern might have, including something that has nothing whatsoever to do with their service here, or does it still need kind of a tie-in to the legislative business of the House? I mean, some of these are pretty easy. If it occurs on the premises, if it's a lobbyist, if it's the press, if it's some person who regularly comes up to the Capitol to do business, I think any third-party policy is going to cover that. There does begin to be a gray area when you get a little away from the building, but you're like, well, this is sort of still occurring in a quasi-official capacity at a social function that's related to legislative business, which, as y'all know, there are a bunch of those. So I think the idea and the options that we have proposed based on the direction I think y'all want to go is to have some applicability to third parties, but somewhere to tie that into something that has to do with the business of the legislature and not, every aspect of everyone's life 24 hours a day. And again, that's not to say that members or employees or whoever couldn't do something that would be a fireable offense or an expellable offense in that capacity. It just comes to what belongs in this policy versus what doesn't. The second issue, what happens once you have an investigation if there's a member involved, I think is what you said. The current policy is not extremely clear about that, and one of the issues that we have discussed with y'all is making it more clear. There are a few different options available. I think what the current policy implies is that comes back to House administration. That could be perfectly appropriate, or it could be not appropriate at all. House administration does have some control over things like members' staffs to some extent, and budgets and parking spaces and all sorts of other things, but it's not necessarily the ideal place for something like this to come. General Investigating and Ethics, as a previous witness said, is a better fit. Just to not to get too far into the legal weeds, but members technically aren't impeachable. And if you think about it, that makes sense. I mean, the impeachment process is charges brought in the House, trial in the Senate, just like at the federal level. Senate members aren't involved in removing House members and vice versa. It's an internal process that goes back to that constitutional provision I read at the beginning. And then the other option is creating, so you could have GIE pass on those, though. It does have to do with official misconduct. The other option would be to try to create an ad hoc committee of members to deal with those sorts of things. The advantage of that approach is that if you use GIE or you use House admin, you're going to always run into the problem of, well, what if the person being accused is on House admin, or is the best friend of someone on House admin, or the worst enemy of someone on House admin? Same with GIE. I don't think you'd want to be changing committee membership of standing committees in the middle of something just to try to deal with an investigation. If you do something ad hoc, the appointment process could protect against that, because you could find people who don't have any vested interest to look at it. And I know, to get to the earlier comment about y'all being different, there is some truth to that, in that ultimately the only two ways y'all can be removed from office legally is the voters, obviously, or the House itself. The expulsion provision in the Constitution. And ultimately, I think it's hard to create a process that's consistent with that latter approach. We don't control the voters, obviously, but the latter approach, it's hard to create a process that's consistent with that doesn't involve, at the end at least, some involvement from members who make a recommendation to the Speaker or to the full House or to someone as to what has to be done.
Let me back up, though.
Sure.
Before it even gets to that,
Right.
where we were talking about when members are involved, that there would always be a third-party investigator, though.
Right.
We would not have a House employee be involved with that, correct?
Right. So that's one of the conversations we've had, obviously, is the current policy leaves a lot of play in the joints on that. It just says, well, you could do an outside investigation. One of the other states that we looked at had kind of a particularly ingenious way of doing it. It didn't say who would do the investigation, but it just said if a member's involved, it's not going to be an employee of the House, which means you don't necessarily define who's going to do it, because you probably do want to leave some flexibility there, but that you would avoid just what you were talking about, which is an investigation that involves a House member, however well done it is internally. I'm not sure it would ever have the credibility it would need to carry the day. Whereas if you bring in some outside party who has the expertise to do it, they're going to be subject to some of the same criticism, but they don't have that built-in kind of bias against their own ability to be fair.
What about anybody else? Training was mentioned. How far do we go in the policy recommendations, do you think, to include prescription about training? Obviously, we've heard that interactive training is much more effective if we want to actually create the culture that prevents the harassment, which is, I think, what we've been talking about we want to do. But how far do you go in a policy to direct that?
So the policy right now doesn't specify what the training is. It just says you have to do training once every 2 years, the other provisions. The reason I grouped that in sort of the related but not in the policy category is because of that. I mean, y'all could put in the policy a live training requirement. A better option might be offering maybe more than one live training option somewhere at or near the beginning of session. I think realistically we would have to use outside entities to do that. I'm not sure that House staff could put on a credible training in that period of time. And maybe it's not mandatory, but maybe as an incentive, if people attend that, they meet their training requirement for the next 2 years. That probably would need to be worked into the policy a little bit, but the specifics of the training are not laid out in the policy as it is. So I've sort of viewed that as one of those additional recommendations y'all could make that with the cooperation of House Admin and House Business Office could be realized.
So what we can expect right now is the kinds of things we've been talking about, and you're working on this draft, is we will see some kind of a document within the next 2 weeks that will incorporate the things we've been talking about.
Right.
And then we can decide as a group, does it cover everything we think it needs to cover? Is there any further tweaking that needs to be done? And then we would submit those as recommendations to the speaker who appointed us to do this.
Right.
And the recommendations, as you said at the beginning, would be recommendations of how to use the recommendations. So would it be through housekeeping rules?
The I could see three options to have it go before the full membership. Two are the things that y'all are all used to from past sessions. Very early on in session, you have the housekeeping resolution, which is typically it's sort of the much shorter version of what the personnel manual later turns into. It's office budgets is usually the most attention-getting item. Other things, house audio videos, been an issue in the past. There's usually one or two issues that also related to house facilities or whatever the case may be. This is, I don't want to suggest it has to be done one way or the other. If this is going to go before the whole house, housekeeping is probably as logical a place as any, because again, the personnel manual grows out of the housekeeping resolution, and that's where it usually is when it doesn't go before the full house. The other option would be the rules. The rules, of course, with maybe a slight exception here and there, are really less about these sorts of personnel related actions and more about proceedings on the floor and committees and all those sorts of things. Whatever happens, there may need to be just a nod in the rules to the fact that this policy exists. Maybe there's a provision already about the speaker's authority extending to ensuring proper parliamentary conduct among the members. Maybe there's also a reference, and compliance with any other relevant policies or something like that. The third option, I suppose you could do it as just a standalone resolution. The rules and the housekeeping resolution are both House resolutions, HR 3 and 4, 2 and 3, whatever they usually are. I don't know of a good reason to do it that way. Either way, it's going to go before the full body no matter what. But I think those are your three basic
But what we're
options.
talking about is going before the full body as opposed to just going to the House,
Correct.
to House administration.
And the other thing to point out, just to emphasize, if you go the House administration route, the usual route, aside from that potentially not being appropriate substantively for what y'all want to recommend, there's also a delay issue. House admin obviously doesn't meet until committees are appointed, and typically there's a lot to go through in the personnel manual, and it is, I think last session it was adopted like March 9th or 10th.
So there'd be a real delay if we went
If you
that
do
way.
it that way, you're going to go 2 months of session for no really
reason.
good reason without implementing the new policy.
Not to change the subject, just a question. The reporting online, can we do that reporting online? How does that work? The suggestion was
Well,
that,
you could do online reporting. I guess the question would be, are we just talking about an additional way for people to report things?
Mm-hmm.
Now, I don't know that it can be entirely online, because if something is alleged that's going to require an investigation, you're going to have to communicate with the person who is bringing the allegation. Now that, I suppose, could all be done online.
I see. Just asking the question. Right now, how is it done? Do you call the hotline?
I think the assumption now, the policy doesn't say it has to be done any particular way, but I think the assumption now would be email, phone, in person, one of those options. Now, the reason I hesitate a little bit is some of the online reporting ideas that are out there are designed around more than just this is an additional way to report if you're more comfortable doing it. Like, we talked about some of these information escrow kind of concepts, or anonymous reporting, or those, I think those raise different issues that are not just about here's an additional way you could report something. And if y'all want to discuss those, we can, but I think those are different than just the method of communication.
So if somebody reports something by calling, who do they reach?
It would depend, in the current policy, it would depend on who the person, the alleged offender is. If it's a House employee or intern, it would go to House payroll and personnel. If it's a House member, it would go to House admin. And then there's a carve out in both of those. If that person is the person being accused, that you would report it to someone else, obviously.
Okay. But that's still in the
That's the
new
current
That's
policy.
current,
Right.
what we adopted in December.
Right. And the new policy, is it going to differ? We've had that discussion, I know.
Well, of course, we haven't, not finalized yet. The other issue that you would obviously have to deal with, in addition to what I just said, is if you go down the third party road, where do those get reported? And because those sorts of complaints don't exist in the current policy. So once they come in, you have to plug them into one of those processes or something else.
Okay, thank you.
Sure.
Anybody else have anything
Questions?
you want to say or ask about, or just say in general at all? No? Okay,
Well,
yeah,
I guess
please.
I would just say that, I'm glad that we're taking a look at the outside parties, because that was something I brought up when we
Yeah,
first
you
started
did.
this thing. And having been a supervisor of people for many years in a large company, knowing that we have an obligation to prevent a hostile work environment is on the supervisors and the leaders of that organization. And in my experience, it's always extended to people that come in from the outside. I've had customers that have been a problem for some of my employees, and that's a very difficult thing to address, because you're a company, you're trying to make money, but at the same time you have to protect your employees. And I've had to tell customers, hey, you can't come in here anymore. You can't do that to these people. But that's what we're required to do as leaders. And I do know that there have been times, or at least I've been told there's times, where there's been folks that have been abusive to our staff members, and that's not appropriate, and it's our obligation to handle that. So I'm glad that we're at least addressing that in some way.
Yeah,
I think
thank
it's
you.
important.
Yeah, absolutely.
Okay, well, if we don't have anything else, then the next step will be for us to get a copy of this from John, the draft that we can look at, and we'll make some final decisions about that and about how we want to pass this on to the speaker, and then I think our work will be done.
We'll
So,
probably do that. Do you have a preference, whether conference call or just making written comments to a document?
I think you're going to maybe, you might have the document ready for us to look at by when?
We'll get to work. We need to go back over everything from today and just plug in whatever we would want to for a draft.
So we don't need to have a
Fairly
date,
shortly,
but
yeah.
shortly. Okay, so we can just get back with everybody once he gives us an idea of when we'll have it, and then we can schedule a time to visit after we've had a chance to look at it.
But do you have the title changed to workplace conduct or something, appropriate workplace conduct?
That is a change that's been talked about and
Okay.
that I anticipate being in the draft, yes.
Okay.
Yeah, you kept bringing that up. Sorry,
I'm sorry.
we didn't mention that. Yeah, that was in our
That was on
discussion.
a-
You're right. You had talked about it, and others
On
have
the
talked
call,
about it.
yeah.
So right now, that is part of what's being looked at in the draft proposal, is changing the title. Right.
I guess telephone conferences, you asked, how it should be done, just comments or a telephone conference. I would prefer a telephone conference after we've had a chance to review it.
Yeah, okay. Okay, we'll do that. Okay. Anything else? All right, thanks so much, John, and everybody else
You're
that was
welcome.
involved. We appreciate it.
Thank you.